get started. First of all, thank you for attending today. I called a press conference today to provide the public information on the grand jury proceedings relating to the criminal investigation of Corporal Derek Collings of the Albany County Sheriff's Office for the shooting of Robbie Ramirez on November 4th and to discuss next steps. First, I'm truly sorry for the death of Robbie Ramirez. I was contacted immediately after the shooting by the mother of Robbie Ramirez, and it was prior to actually being advised as the county attorney that a shooting had occurred. His mother wanted to know from me why. How could this happen? Those comments from the beginning have carried with me through the entire investigation and to the point that I stand before you today. After the shooting, I was immediately questioned by law enforcement whether I should remove myself from this case due to me being called by Robbie's mother. And I knew, due to the fact I knew his mother in a capacity of a mental health board. At that point, I even questioned, well, I know the officer too. How is that any different? I felt I had no legal conflict at this time. As a matter of fact, I had researched this issue after the first shooting that had occurred in 2015 at the Snowy Range Ski Resort, which was involved Albany County Sheriff's officers at that time. In that particular shooting, as I did in the subsequent shooting at Vidavoo and this shooting, I immediately reached out to the Wyoming State Bar Council to discuss whether I had a legal conflict. And each time I discussed, I followed the advice of what I was told and discussing this matter with that legal counsel. In the first shooting that occurred in Snowy Range in 15, the officers involved were the judge's son, who worked for the sheriff's office. As you can imagine, I practiced in front of that judge on a regular basis, and I had a legal conflict and requested to be removed from that case. And I did so, and at that point I reached to the Attorney General's office in an effort for them to handle the review. In the second shooting that happened since I've taken office, that occurred at Vidavoo. Again, an Albany County Sheriff's Office deputy was involved in that shooting. And I did not, as I reached out to Bar Council, recuse myself of having a legal conflict, but made that decision. But up to this point, I question our system in the state of Wyoming and how we investigate officer-involved shooting with deadly force. At that point, I reached out to my colleagues throughout the state of Wyoming, and I reached to them to see what their thoughts were, and how could a county and prosecuting attorney who represents the Albany County Sheriff's Office in a civil capacity also investigate a sheriff deputy. In addition, I reached out to various attorneys as to conflict. I researched American Bar Association. I looked into this matter thoroughly to kind of understand when there was a next shooting, how would I handle it, and what I would do differently. What's most noteworthy in the state of Wyoming, there's no state statute on deadly force. There's no protocol. There's no process. It's basically the way it's always been done in the state of Wyoming is that the DCI, which is the Division of Criminal Investigation, would investigate the matter, and then they refer it to the county and prosecuting attorney or DA in that community to determine if it's justified. In reviewing that process, I felt we could do it better. And I had, back then, decided that I would consider a grand jury. But when I just started discussing a grand jury, I wish I would have personally handled it, because it would have been handled differently in the way our community would expect me to handle it as being elected as your county attorney. But in this case, I elected to stay on it for many reasons. And the reason that stood out in my mind was back to how could this happen in our community? I felt by a thorough investigation, and I assure you, law enforcement did not agree with every move I made, but I stood true no matter what the public said, no matter what law enforcement said. I knew this needed to be investigated properly and thoroughly, so we determined how could this happen in our community. I sat down and I looked to other jurisdictions, and first thing, what I find amazing is no one even knew what a grand jury really was in Wyoming. The last grand jury, and from evidence I've received, was 1992 or 3 for a gas fixing case and had nothing to do with the criminal and type of these charges. At that point, I decided the grand jury would be effective, not because I feel that in other states it's ineffective. I felt in the state of Wyoming it would be the best course of action. It would require each and every one of us looking at the evidence, examining the evidence, asking those questions that I've read in the social media, asking people to be accountable. And I asked those questions and I investigated. Not only that, I secured 2 experts to come into our community in order to provide insight as to national standards and how it should be done in the use of deadly force. Those 2 experts, and I had contacted another expert, but they were not available over the holidays to testify, actually came in following a model that I've seen in Wisconsin. This grand jury process differs from other states in that this is not a grand jury that sits for every case that's handled in our community. Instead, this grand jury is convened only for one matter and one matter at all, and that was this shooting and whether it was justified and whether criminal charges should be filed against Corporal Derek Collings. At that point, what most people don't know is this jury gets to ask questions. They ask questions of every witness. They ask questions of me. A lot of the questions were what I had already known from social media, and those questions were asked in detail and putting those witnesses on the spot to know why. How did this happen? There was a thorough investigation, and no disrespect to defense attorneys, it was more raw, more direct towards those witnesses than you would ever have in a courtroom with a jury present with a judge. Yes, the judge was not present, but let me tell you, I asked the judge about specific rulings of what was relevant. And 2 things that I discussed with the judge that were not presented were the prior shootings of Derek Collings. Why is that not relevant? It was because I would need to present the facts on each of those shootings in this case, which takes away from the relevancy of the facts of this case. Furthermore, I did not present the facts concerning the victim in this matter, Robbie Ramirez, and all of his law enforcement contacts and assaults that had occurred back in 04 and 05, resulting in the assault on 2 officers and the assault of a family member. I felt, again, that required facts being introduced and re-entered into this case, which did not have any bearing. The grand jury asked questions. Those questions were asked, but they were told as to the relevancy and how we were focused on this. This is a criminal process, a criminal crime. He was charged and asked to be reviewed whether he committed the offense of involuntary manslaughter. It is a specific definition under the state statute of what must be proven of the elements. And one of the key elements, was it justified? Now, it may not be the result that some people wanted, but I will submit to you that the system did not fail. The jury system is there for a reason, and this system was done fairly and the evidence was presented. No one is happy. Law enforcement's not happy that I now have said in Albany County, we will put deadly force to a grand jury. The citizens aren't happy because in their mind, he should be criminally prosecuted for the acts he did on this. I am here to tell you that the evidence did not meet that level of probable cause. And at this point, the next steps are, where do we go? Well, I'll tell you, it goes back to that question that it was asked of me. How could this happen? How could this happen, and why did it happen? And so that takes the point of an elected official and all of us to now start looking at where do we go from here. With every case I take to a grand jury, and every Wednesday I hold case reviews where we look at facts. We look at the officers and how they acted. We look at what could we do differently in our investigation. And that's exactly what I intend to do with this case. I believe that DCI and how this was investigated and how this matter was handled needs to be reviewed. And I intend to do that with one of our experts to facilitate that dialogue as we self-reflect on how can we do better and how we handle this process. This process, and what we had here, should not be what's happened today. We shouldn't have had to have citizen groups formed. We should have policies and procedures in place. How do we handle when the unfortunate use of deadly force is used? We have none. We have no policies. No one has policies of the prosecutors. So we need to do a better job on how that's handled. We need to do a better job on how we communicate what was going on. Grand jury proceedings are secret. They're secret for a reason, in order that the attempt is to get the information to the grand jury. At this point, I think the process needs to be looked at, maybe on a state level. How do we handle deadly force as a state? How do we handle it with training? Some of the things we're currently doing is with the Albany County Mental Health Board and looking at CIT training for more intervention. But I'll submit to you, even with this process, we never looked at it from a traffic stop perspective. How do you know when someone's mentally ill in a traffic stop? We've never approached that. I'm not sure if that's been approached nationally, but it needs to be approached as well. As we move forward, the next step now is personnel. And that will be handled by Sheriff Malley. Sheriff Malley has an attorney that will be retained in order to help him. What you don't know is I removed myself from the personnel matter exactly the first week and asked the county commissioners for him to retain counsel. I removed myself from the civil piece of this and kept myself on the criminal portion of this investigation. In addition, I received correspondence early on in that first week about the potential of litigation. Underlying all this has been several areas of where this particular matter could go, and rightly so. We all should be accountable for what happened. And so with that, we have a civil attorney. So the civil attorney is also representing. My role was solely the criminal and how it would go forward. At this point, again, the question needs to be answered. How can this happen? I know that there was a citizen group. I attempted to attend that. I was called by ACL specifically and told not to attend. This is not the way, and I was told. As an elected official, people did not feel safe to open up and to talk. Well, we need to have these difficult conversations, and they may not be difficult for people to hear, but we need to hear that. And part of having a case review, we also need a facilitator that's unbiased to come in and facilitate that dialogue as to how we can make the changes so this doesn't happen again. But at this point, I felt it was necessary to have this press conference because I believe facts were not getting out. And quite frankly, the way the process was, we didn't have a process to follow to know how to handle it, and now we will change the way that occurs. So at this point, I wanted to let you know these are the next steps that we intend to do, and if there's any questions, I'd be glad to answer them.
In the last police-involved shooting, at least that I was familiar with, was the Vita one. In that case, you made a determination whether there was probable cause and then released information about why there wasn't, and a lot of details about the facts of the case. You mentioned about why a grand jury was appropriate to let citizens decide, but why was that a better process than putting out in public an explanation of there wasn't probable cause, if there wasn't, and you determined that there wasn't, here's why there wasn't probable cause, and here's an explanation?
Good question. As a matter of fact, at that time, and I'll be candid, I was being told this is the way it had to be done. I was told that it is the sole decision of the DA or the county attorney. I was inquiring of my counterparts in all 23 counties. I'm the president of the association, even inquiring, is this the proper way to do it? And at that time, I had elected, because that would have been my first one to be actually without a conflict of interest to handle. So at that point, I elected to go forward with it and make that sole decision. It didn't feel right. I felt it needed to be responded to from the public. Also, I think the process of going through grand jury forces officers, forces me, forces everyone to do a better job examining what protocols or processes be reevaluated. That didn't occur after that shooting. So that's why I feel the grand jury forced the issue for us to look inward, and not just because it was an individual who had previously been in other shootings. It was this shooting, these facts needed to be examined in a light of community people. And I do want to add on to that, the jury selection in this is unique too. Jury selection for a grand jury is for cause. So if I believe you're supposed to not have preconceived ideas, well, the pretrial publicity was out there that everybody had heard or read something about this. So there were people on the jury that we attempted, I know, to try to get past any preconceived ideas. They could not be dismissed for anything but cause, meaning they couldn't serve for one reason or another. There were 12 jurors selected, and even with the jury instruction, there were questions asked about evidence that we did not present, these two pieces of information that I previously discussed. But it was important that they set aside that and listen to the facts that were presented.
Peggy, Meat Gruber at AP. Can you please tell me when the grand jury met, over what dates, and the breakdown male-female?
I can't talk about the jury itself. I'm prohibited by state statute and ethically, but I can tell you that they were convened early, I think I started filing the documents, I believe, I don't want to, November, but I knew immediately on November, I believe, 8th, that I was going to convene a grand jury. It was January 8th is the date we selected to start the grand jury and select the grand jury. Jurors were called to the room. They thought they were appearing for criminal matter. It was held over at UW College of Law because we had another jury trial going on here, and also the deliberation room here. We did not have the ability for the equipment and how that would look like in a grand jury setting here. So we used the law school. They convened, so the jury was selected on January 8th. Evidence started to commence on the 8th and continued on to the 9th and 10th, and then they deliberated on the 10th and reached their decision.
Were they sequestered in any way over that time?
No. And I can tell you from their questions, they were asking items that were from social media. I had been reading all social media, so I tried to address their questions. Their questions were outstanding. They asked the hard questions that I take back with me of how can this happen and how do we fix it.
What I heard you saying is that given the statutes and policies that we have, the jury didn't find a need to indict Colling. But then you're also talking about how we need a change.
Yes.
So can you talk more specifically about the policies and statutes at the state and the county level that you think need to be addressed?
Yes. So from an officer shooting, it's unlike if a citizen used self-defense. This is justification. And the jury instructions and all of the law does not lean itself to this type of procedure for grand jury, so we used case law of Supreme Court, Wyoming Supreme Court, for justification. So where it provides the issue is, this is not the norm. I think it should be the norm that we convene a grand jury when there's an officer-involved shooting. I believe that there needs to be some higher standard for officers as well as prosecutors when deadly force is used. And so that's what I'm referring, is that we need to have some type of reform statewide to direct, or we will have, as you've heard in the past few weeks, all the officer-involved shootings, it's being decided by a county and prosecuting attorney or DA. And I believe, in my opinion, we need more accountability and oversight, and that provides it by going to a grand jury, which is comprised of citizens.
It still feels like the conversation is limited to a justification of use of force, and I'm wondering if there's a policy conversation about alternatives to facilitate a conversation about things like de-escalation, as opposed to being limited to was this death justified or not?
Well, first of all, I was deciding the criminal component. So now you come back to Mother's question, how could this happen? And that's where the question, because of the investigation, because of the thoroughness of grand jury, it allows us now to ask those questions. How could this happen? What could we do differently? How can we look at traffic stops? How do we identify, if we can, whether someone's acting out of anger, ready to attack, or mentally ill? How do you handle it? Can you de-escalate it? So these are conversations that came out of it as a result of the criminal process. It's not saying that de-escalation necessarily is in the elements of the crime. It's what do we do now for policy?
Now, do we know what's next for Colling? Can the public expect him back on the streets?
You will have to direct that to Sheriff O'Malley. That is a personnel matter. As a matter of fact, I'm the criminal. As I had indicated, there will be an attorney that will be representing Mr. Sheriff O'Malley, and at this point they will deal with that separately.
Right. And would that also be where to direct a question about possible protocol breach during that traffic stop? And you just had talked about a de-escalation, but kind of what led to just sheer aggression right off the bat?
That's where that conversation will occur during a personnel matter. Did he adhere to all of the policies? Reflecting on training and so forth like that.
He does remain on administrative leave pending the sheriff's determination?
As far as I know, he's on administrative leave as of today, so he's still on administrative leave. Mr. Hale.
Yeah, several questions. I assume there will be some preservation of evidence so that we don't have a repeat of the shredding incident with the resume or that the city had. That's one question.
I'm not familiar with that.
Yeah, the resume over the director at the rec center.
Oh, okay.
Secondly, am I to understand that the grand jury couldn't listen to the evidence and ask questions if the public was there? I fail to see how the connection or the justification by not having the public there. And then third, do you agree with that process that the public should not be involved?
Okay, first of all, your first question as to the matter over at the city and shredding of evidence, just to let you know, we have preserved all of the evidence. As a matter of fact, we received a letter early on. We've preserved everything and nothing will be, how should I say, destroyed. It'll all be preserved for the case. The second issue you raised is the grand jury and how the public is precluded from that process, and it's done in secrecy. That's currently the state law, and that's kind of the process. It is, not kind of, the process throughout the United States for a grand jury. I want to clarify the difference between a federal grand jury and state. Federal's convened regularly. State is not here in Wyoming. But it is secret, and it is to the point where public is precluded and no one is permitted in the room but the grand jurors and myself and the court reporter, and that's it. And they ask questions back and forth of what they want as I present the evidence. So they're holding me accountable to what I'm presenting. And your last question was, do I feel the public should be involved? I believe the public, this is a crime, has occurred. Let me give you the difference of a grand jury. Normally in Wyoming, we don't convene grand jury. I worked under that system as a prosecutor in Ohio where we convened a grand jury. As a matter of fact, I did a stint in the grand jury division. And basically, you would present all of your felony cases to the grand jury. To me, you get to know your grand jury, and it's more what people feel that it's not a good process because it's kind of everybody knows everybody and they just kind of go through and rubber stamp it. this process is unique because it's convened specifically for this, and it was done more or less on this case, and there's no relationship really. You're just, they don't know me, I don't know them, and they're just asking the questions. As to the public being involved, this is a criminal. I charge felonies in my office. I have officers sign what's called affidavit of PCs attesting to the facts that result in that, and then it can go to the preliminary hearing to determine there's probable cause. There in the preliminary hearing, the public is involved. But in this case, it was more into justification and determining was it justified or unjustified. I have to admit it wasn't until at the close of the case that I could say my mind was even made up. And I think that the grand jury did a great job in listening to the evidence and asking the hard-hitting questions that they did throughout. So I think I answered your question.
Well, I think the problem that the public has, I know I certainly do, and that is when we have elected officials, such as yourself, talking about accountability and transparency, and then when it comes to walking the talk, it's going to be secret. The two seem to be conflicting.
The other process was for me to make the sole decision, and I think that's even worse. So in our system in the world right now, there's two ways. Either the prosecutor makes it sole decision, one person who's an elected official, or we go with 12 people to ask questions and who make those decisions. And you can convene your grand jury for other matters too, but we elect not to and have not. Now that I know the process and we've now created it, I may use it more often in certain cases, and I could tell you those would be reserved, I know, for officer-involved shootings right now. But I do believe that that is a better process than one person making the decision.
Yeah, two questions. One is, what efforts did you make in screening your expert witnesses to make sure that they weren't unfairly biased toward law enforcement? And why was there not an expert witness who was specific to mental health or police shooting, like victims, advocates, something along those lines?
Good question. There were several experts that were provided to me, and actually 3.
But who provided them to you?
Another law enforcement agency, DCI, and others provided me names. I also did a Google search to see what was out there and experts in this area and trainings I've gone to personally and I've seen. So from those experts, we were able to dwindle it down to 2 experts, and what was really of concern to me was not only the use of force and whether, the policies and national standards, but also someone that could come in and review those items. Also, I had questions about the taser in this case and the video camera, body camera, and they're by Taser, the same company. I really wanted to be able to answer, how did that video camera turn off? How come the taser didn't work? Was it activated properly? I wanted that investigated thoroughly so that I understood what was happening. Wanted to know, is it common practice to pull a taser and a firearm at the same time? I wanted to know those questions as we were going through the policies and national standards, because we wouldn't know those national standards. Standards and policy are driven by case law. Case law, then the sheriff's office or the law enforcement can even add stricter standards. But getting back to mental health, those records and everything, even though it wasn't provided to the grand jury, all of that was provided to the expert so that they had the mental health records and all of it. What they were focused on, and I think what people don't understand, was the traffic stop. There was evidence. I wanted to know how he didn't know, just like the mother asked, how did he not know him? That was a question that I kept coming out. How do you not know him if you went to high school with him? How did you not know him that day? We were very focused on looking at that video to kind of determine, did he know him? Was there signs of that? So the expert was focused on this, but this was a traffic stop, not what we normally get, and I deal with our involuntary commitments in our office personally, not the typical where we're called out, officers are called out to a scene to intervene with a mental health crisis or anything that's happened. This was a traffic stop. So we're looking at it from that perspective. As I said, where do we go from here? How could this happen? These are things that I think that needs to be looked at for training. But yes, those were all given to this expert, everything.
Yeah, I guess I understand that there was technical information that you were asking him to evaluate. What I'm talking about is bias, though. Like,
Oh yeah. I even asked the officer, the officer, how do you, you seem pro law enforcement, so is your, are you going to move? And the answer is no. He gave the good, bad, and everything in between to the grand jury of what he observed. You have to remember this is a criminal charge of involuntary manslaughter. The policy issues is a different issue, different area. But he was. You have to understand policy of law enforcement. You have to be a law enforcement officer to understand it too. You couldn't come in and evaluate a police just from that. You're looking at the outcome versus process. How does a police officer respond? There's a different lens that you're looking at it.
so speaking of the body cam footage, is that going to finally be released to the public?
Yes, I have been advised by the civil attorneys I am not to release it, and against their advice, I'm releasing it. I believe it should be released. I believe in the public records. I said I would, and I will. We brought copies. The problem is the dash cam is left on for several hours and takes a long time to download. But I can release it all you want. You can look at the body footage. I can tell you right now, oh, I apologize. I can tell you right now the footage is no different than what you have on YouTube. I think people in the community they think the answers are there. There's more to this. It's subjective too. What was going through the officer? What was going on in the mind of what happened afterwards? What evidence was collected? It's more than just that video that is out there. But sure, you can have it, but it's against legal advice. I'm probably going to get in trouble. But I've decided that I believe the body cam and the dash cam and the radio traffic should all be released. So I will be releasing those. The problem is, again, getting it downloaded and being aware of that.
And where was that shift from originally when we had come to that first conference to then now wanting to release it?
The criminal investigation is complete. Grand jury has made a decision. I have nothing further to deal with the criminal aspect. Now it's moving to the civil arena, which is personnel and civil liability. So that to me, just like any other felony or criminal case, I would release what is necessary. And in the state statute says I may release it, and I believe I no longer have a reason. I knew early on when we had done the press conference, I was moving in that direction, and I knew I was going to and could not release it because we were analyzing that footage.
Now, is any of the evidence that the grand jury saw going to be
No,
released?
all of that is sealed right now. That will be up to the civil attorneys eventually. I do anticipate filing a motion to unseal it, but at this point I'm not doing that. The civil is kicking in now, and then all of that will go forward.
Peg, this is kind of a convoluted question with that subjective element that you discussed, and you mentioned that you consulted with Judge Bricken about the relevance of the previous shootings that Derek Collings had been involved in, and it kind of gets to that, like, just the general 404B concept of
Other acts.
of establishing a pattern of conduct. And I was wondering if do the same principles on 404B exceptions apply to a grand jury as they do to a jury trial, and if so, does the pattern of conduct have any relevance to an officer's justification, and if so, why is that not relevant?
That's a great question. The case law doesn't dictate that that would be admissible, and rules of evidence do not apply, which meant there was hearsay. That's why the jurors could ask the questions even though it wasn't adhering to the rules of evidence, a lot of their questions. But essentially, other acts, you would have to show those shootings were similar and situated if we were to do 404, other acts, and you don't have that here. Those were each individually different circumstances than this. On the flip side, should we have entered the victim and their acts of assaulting an officer and or family member as being violent? And I felt that that was inappropriate because you have to look at this facts because those facts were different. So there was that looking at both to see, can you admit it or not. We did talk about his mental health condition on that day. We did talk about his, I can't get into it, but we talked about different things along that line.
And aside from Judge Crimmins, did you consult with the AG or bar counsel about what evidence to introduce and how to introduce it? That's
Bar counsel, no. I only talked about legal conflict. AG's office, yes. I did speak with them about evidence, not detailed as you think, more just jury instructions and what the law and how to advise the grand jury. We had never convened one. As a matter of fact, one has never been convened in the state of Wyoming, so it was working together to figure that out. I did consult with other county and prosecuting attorneys and DAs throughout the state. They also factored in talking to me as well.
Now, what's next for your office and law enforcement? It's clear that there's a strain between you guys and the community now. How are you moving forward?
One step at a time. I have a job to do. I was elected to do my job. Regardless of this case, I did the right thing in my mind for making this accountable. I just keep moving forward to take each case, and we had a full weekend, and you just keep moving forward. As to moving forward as a team, I believe in a case review. A case review will actually examine the process and how we can do it better, and a facilitator talking to myself and the Sheriff's Office and DCI and how we can do this better.
In terms of the process of changing policy moving forward, what would you say to people who said there was no indictment, so we don't have a problem? I mean, I think that people see impunity as an indicator that nothing's going wrong and potentially see charges as a sign that there is a problem. So how do you explain that to maybe Collings coworkers or people in the community who are like, oh cool, it's over, it's done, no indictment?
Well, first of all, you have to know what I brought to this office in case reviews. And if I had the media here for every sexual assault trial we go and there's a not guilty, let me tell you, the debriefing is heavy when there's a not guilty to figure out how can we do it better, how could we present the evidence. It's the same thing in this case. I view this as serious, how could we do it differently, what we could do. But a lot of this requires Sheriff Malley, and it's on his shoulders of how he takes this and proceeds with his deputies. And I think he is, at this point, looking at bringing in that expert to examine the policies and determine what we can do better, kind of listening to what other actions that could be implemented in the future. And I guess that's upon us as elected officials to make that happen. Another reason why I wanted to stay in this, to make it happen and to follow it through. And if you don't know me, I basically, when I say I'm going to do something, I did it. And I did it with juveniles, and I'm going to continue with mentally ill and how we handle it.
Can you tell us the vote count on whether to indict?
As I said earlier, I'm unable to do that. The rules specifically prohibit me from telling you the vote count. I want to tell you so badly you don't even know, because I think it would answer a lot of your questions. But at this point, I can't, and I'm prohibited. I even had to call Bar Counsel and ask Bar Counsel if I could please tell you. I spoke to the U.S. Attorney's Office because they deal in federal grand juries. I am prohibited by law. And even if I told you, then you would know the vote. So I can't even tell you.
Who's the civil attorney representing the sheriff?
Tom Thompson.
Can you expand just a little bit on what are some of the actions that could be taken after you review this case? You've talked a lot about the questions that you're going to be asked, but are there actual changes that can be made, or is it mostly you guys would make suggestions to maybe the sheriff's office about policy changes or things that you think need to
Right.
be different?
Well, some of the changes is we need a protocol and a process. We have to figure out for the next shooting, because it could happen today, how are we going to handle it? How am I going to do it differently? I've learned a lot. Some of you from the media will laugh because I was told by someone back there that we should have a press person and we should know how to do this, and I don't. I wasn't prepared, and I'll be candid with you, we hadn't had this in our office or the staffing levels to do that. I've learned a lot from this. And I think immediately there needs to be a process and protocol, how the media, how the public is informed. I believe that there does need to be transparency and openness. I thought I was doing the right thing. I actually called Casper, which is where I heard, I probably didn't, I'm not following the way Casper Police Department did it, but I actually called Casper and handled it that way by doing a press conference. I felt I could not, because of the grand jury, I knew I was going to release the evidence, but I thought I could at least show it and address it immediately. So I think lessons learned, I was told afterwards, and unfortunately everyone told me you should never have even done the press conference, and I disagree. I felt I needed to do that to get it out. I guess the mistake is I didn't put it on social media. I didn't know how I should have done it. Another lesson is learning is we need to immediately get mental health training of officers implemented immediately. Right now, we are working and moving in that direction, but we need to move quickly. We haven't had that training in numerous years, and it has to happen, just in general, not just, and then kind of carrying it over to traffic stops. I do have the ability to help with that. But the other material reviewing the actual policies, that's going to have to come from Sheriff O'Malley's office.
So just to be clear, you guys can review that and kind of push for more training, push for those things. But as far as actually having the authority to make those changes, that comes from the sheriff's office.
Correct.
Okay, cool. Thank you.
Okay. If there's not any other questions.
Go more, Peggy. So a number of us understand that grand jury findings are actually recommendations and not binding, and that ultimately it is still your choice whether charges are pressed. Is that true in this case or not?
No, it's not. In Wyoming, it is, they made the decision of no bill. That I am bound by that. I felt their decision spoke loudly to me in how to proceed. I did reach out to the U.S. Attorney's Office to inquire about a 1983 action and or criminal action, civil action, doing that. At this point, you'll find that amusing because the government shut down. They're non-essential personnel at the Department of Justice right now. But I did speak with a representative in the U.S. Attorney's Office. If that's something that does happen, which, with disclosure of evidence, that's another reason we're kind of dragging releasing anything in the motion for the sealing of the grand jury, they would need that evidence preserved. But I am not, due to the grand jury's findings and what was communicated, I will not be requesting that. But if the family goes and requests it, that's fine. And then they will conduct their own investigation by FBI. And I thought that's what ACLU had communicated to me at some point in some conversation, that they were going to do that. But from DOJ, I may be incorrect.
Sorry if I can ask a question. When you were talking about the experts who testified that they knew about Robbie's mental health issues, did they, and you said the mental health issues were off the table along with the prior shootings, was the expert aware of the prior shootings or just the mental health issues?
All of it.
All of it.
They received personnel records, everything. They received everything in its entirety. And I won't say mental health was not off the table. I want to clarify. Mental health was presented to the jurors so that they knew, because you needed to take in his condition at that day. That was relevant to know, that he was mentally ill. I think through some of the testimony we learned a lot about Robbie and why he may have done what he did. But we don't know, at this point, it goes back to the traffic stop and looking at how we handle that. Okay. Is that it? Okay. Thank you very much for coming. I appreciate it.